second reading of the Foetal Sentience Committee Bill. Lord Moylan.
My Lords, I beg to move that this bill be now read a second time. My Lords, in rising to propose that this bill be read a second time, I do so with some trepidation, not because this is a momentous bill, but on the contrary, because it is a very modest measure indeed. If I go through its clauses, which are very few, the first one establishes a committee. It requires the Secretary of State to establish a committee. It allows the Secretary of State to appoint the members of that committee. I haven't chosen to specify who they should be or how many they should be, because I trust the Secretary of State in whatever government, of whatever political colour, to make sensible decisions about that and to appoint appropriate and skilled people. And the clause also states what the purpose of the committee is, which does bear reading out. It is to be a source of evidence-based scientific expertise on the sentience of the human fetus in the light of developments in scientific and medical knowledge, and to advise the government on formulation of relevant policy and legislation. The second clause requires the committee to publish reports. It actually requires the committee to publish only one report per annum, which is an annual report for the purposes of transparency, saying what the committee has done and giving an account of any expended income or expenditure it's had and who its members are, a normal sort of annual report. The government is not required to respond to that, but the committee is then free to publish further reports of a more scientific character. Clause 3, I'll come to that, requires the government to respond to reports of that character. The other part of Clause 2 is language that ensures that the bill is consistent with devolution legislation. Clause 3 refers to the response the government has to make to those reports. There is nothing to stop the government responding by simply saying that it has noted the report, if that is as far as it wishes to go. And finally, clauses 4 and 5 are supplementary and general clauses that I've been advised are appropriate for this bill. Now, why would such a committee be needed, and what is the value that it has? The question of human fetal sentience has been addressed by a number of bodies, but principally by the Royal College of Obstetricians and Gynecologists. And as the very helpful note from the library makes clear, to date, their conclusion at the moment, their current conclusion, because of course this is a shifting and developing scientific field, is that to date evidence indicates that the possibility of pain perception before 28 weeks of gestation is unlikely. But one of the members who formed the committee that reached that view has now changed his mind and takes a view that the perception of pain could arise as low as 12 weeks, while the British Association of Perinatal Medicine takes the view that fetuses born as early as 22 weeks gestation do show physical and physiological responses to pain, and there is no reason to think that fetuses at this gestation are any different. In addition, it might be said that the NHS recommends the use of analgesia for the fetus in the case of operations in utero for spina bifida from 20 weeks onwards. So I think it's fair to say that there is considerable breadth of view on on this question of human fetal sentience and when it kicks in, and that we would all benefit, government would benefit, but so would all the relevant professions, from having a forum in which a clearer and more determined view, and one which developed over time, could be thrashed out between different medical professions. It would also have the advantage that the government generally, in responding to questions on this issue, has tended to rely on the work of the Royal College of Obstetricians and Gynecologists, which places a heavy burden on them And an advantage of having a committee such as I propose would mean there were opportunities to bring together other royal colleges, including those representing paediatricians and midwives, and others indeed, so that their view could be contributed on an equal basis. Now, this all brings me to the question of advances in medicine and medical science and rapid advances in surgery, because I've referred to the cases, rare but important, of operations in utero for spina bifida, but there are other reasons why operations may need to be carried out on the human fetus while still in the womb. And there are also cases, of course, where it is necessary to operate on a pregnant woman for her own sake, and in those circumstances, consideration should also be given to what consequences might arise for in relation to the sentience of the fetus that she is carrying in her womb. But all of this at the moment is being conducted against a background of inconsistency of professional opinion. And if one says, as one could, that this should all be left as a matter of clinical judgment to the medical practitioner, I am all in favour of medical practitioners being able to exercise clinical judgment freely and professionally. But in fact, it's very difficult to do that without some sort of agreed guidance. And in fact, we don't, as a matter of practice, leave practitioners free of guidance. There is a great deal of guidance on a range of topics which they follow when they are carrying out their necessary and valuable work. And so I don't think it impinges on the freedom of the medical practitioner to exercise their professional judgment that there should be a better informed agreement on the occasion, the time at which fetal sentience arises, than currently exists, given the inconsistencies that I've drawn attention to. There are also inconsistencies, my lords, with the way in which we treat sentient animals. The Animal Welfare Sentience Bill 2002, which came through your House, in fact establishes a precedent for this bill by requiring the government to set up and maintain a committee precisely to give it advice on policy in relation to animal sentience. And that bill, noble lords may recall, declares mammals to be sentient and certain categories of shellfish. I'd be surprised if my noble friend the Minister wanted to say that a human fetus should be denied the same esteem as a lobster. But in fact, that is the current position. We have legal protections for lobsters and for decapod crustaceans. I remember the discussions in that bill about these particular animals, as well as all mammals. But we have no view, let alone protection, for the human fetus. There's also an inconsistency with the Animal Scientific Procedures Act of 1986, which defines protected animals and protects their fetuses from 2/3 of gestation, so from the point 2/3 through the gestation period. So we have legal protection for canine fetuses from 7 weeks onwards, but we don't even have informal policy advice for the human fetus and its own sentience. This bill would open a path to correcting that by allowing science to come together, scientists to come together and reach an agreed view and a developing view in the light of new discoveries. Finally, my lords, I come somewhat reluctantly to the question of abortion, which I haven't mentioned until now, because the bill is not a bill about abortion. And as I say, the question of sentience is much broader than that and relates to those who relates to fetuses where the mother is extremely keen and devoted and committed to the healthy birth of, as indeed are her professional carers, to the healthy birth of that child. The bill does nothing to change abortion law. It does nothing to change the way in which any proposed future changes to abortion law are carried out. It has no implications other than providing a focus for scientific knowledge on the course of legal developments relating to abortion. And it does nothing to impinge on the legal rights of women to terminate a pregnancy. Anyone who argues that it does, it seems to me implicitly, is arguing for the view that those rights are only defensible if scientific knowledge is somehow suppressed and dispersed. So, my Lords, this is a modest bill intended to provide scientific knowledge and to inform public debate. It is also based on a clear precedent that was advanced by the government. The Animal Welfare Sentience Act was a government bill. It's hard to see on what grounds the government or noble lords would object to it. And so, my Lords, with your agreement, I beg to move.